Okay, I'm going to start right here. The majority of the litigation in this case occurred when Brianna was self-represented, which was from 12/3/24 to 4/15/25. John has buried Brianna in litigation to establish a false status quo for W in Texas as follows. 1/15/25 ex parte RFO to modify the 1031 stip and order by requiring Brianna to exercise her visits in Texas instead of LA. John admitted Brianna exercised some of her time with W in Texas in 11/24, and the court should note that this did not generate an ex parte filing RE kidnapping nor any filing at all. Judge Nord's ruling on this RFO stated that all of Brianna's visits were to occur in California and Los Angeles, Orange, Riverside, or San Diego counties. Number 2, 1/16/25 regular RFO to correct the 115 orders. John argued, thank you, Diesel. Judge Nord made a mistake. Oh, that's right. I did read this because I said that that form to me was extremely confusing. But anyways, he made a mistake, and surely the court meant the opposite of what was written at the order. At the 3/17/25 hearing, Brianna did not appear and was not represented. The minute order notes no opposition was filed, so John's request was granted, meaning all of W's visits with Brianna had to occur in Texas. This is the junction where the biggest procedural mistake was made on this case. There is no POS on file for service of this order on Brianna. Per CCP 1010.6 C2 and 3, an unrepresented party must provide express consent to electronic service by serving and filing a notice on all parties, or by providing affirmative consent through electronic means with the court and the court's e-filing provider. None of this was ever done in this case. Yet, after Mr. Sands exited the case on 12/3/24, Ms. Budnick improperly served everything on Brianna via email. However, the one thing she did not serve at all was the 3/17/25 order. As again, there is no POS on file. The evidence at trial will show that starting around 3/23/25, John began broadcasting on TikTok, Snapchat, and YT that he was going to get W in LA because he had been kidnapped. He, his mom, and his friends posted video after video documenting every second of this debacle, during which John was behaving as if he was distraught, not sleeping, not eating, and deathly worried about W's safety and location. Hey, lawyer, we were just talking about you. Which is crazy. Oh, lawyer. I don't know if that's your what I was reading the question, but I'm glad you're here because I had a question for you. With Lena being on Bree's witness list, because they're trying to say that she paid whatever. If she was to switch up, now she says she has not been subpoenaed yet and John didn't pay her, etc., etc. But if she was to get up and switch her story up, which we know she's not, but if she did, couldn't she be potentially held in contempt, meaning because she lied under oath? Oh, he knows he's always welcome. He can come up anytime. He knows that. Lawyer got a red carpet over here. Okay. Perjury, criminal charges. Thank you, love. Yeah, I can't see her going up and changing her story. Because again, he never said that he paid her to testify. He said he paid for everything for her and funeral while they were in LA. That was it. You know? Okay, that's what I thought. Yeah, so I can't see her going up and changing her story. And can you imagine? She talks on here about how He documented every minute of this debacle. Guess who else documented every minute of that debacle? Your client, ma'am. Bree documented every single minute of it. Baby W was on camera for almost 48 hours straight with the lights and the TTS and all of those adults around him sitting on this. I mean, it's still, to me, such a creepy moment that you have a small child on a bed with all of these adults like laying around him, and the adult video, all the adults in the video and the TTS saying all those crazy comments. I would be more worried about that than him being worried about where his child was. And if you think for 2 seconds, exactly, sitting on the corn, but come on now. If you think for 2 seconds that John was not worried, is crazy. Yeah, poor baby. Baby W was so sad. It was very sick. I was worried sick, and I don't know either one of them. And I was worried sick. Yeah, everybody was. So to say that he wasn't is absolutely crazy. Okay, so his mom and his friends posted video after video documenting every second of this debacle, during which John was behaving as if he was distraught, not sleeping, not eating, and deathly worried about W's safety and location. The evidence will also show that despite all of this, for the next several days, before John got W from Brianna in LA, he asked Brianna once on OFW how Winter was doing, and made one welfare check by the LAPD. A truly distraught parent that is not creating a kidnapping storyline for profit on this internet based on a non-existent and non-served order would have done much more than those two communications. Again, all due respect, ma'am, how would a lame person, right? If I'm in court and I hear the judge say that this is the order, how do I know that my attorney did not file the form that she was supposed to? How do I know that she wasn't served the right way? I would not know that. Thank you so much. I don't know what to call you, love. It's just a period. Thank you. How would I know that? I would not know. As a lame person, I would have no clue that the paper was not served correctly. So in my mind, I'm thinking, absolutely, she was served correctly. She knows she's not supposed to. And on top of which, he also watched her, I'm sure he did, the rest of us did, watched her read said order before she left. She read the order that she wasn't supposed to leave before she left. So why would John think anything different? He would not know that the paperwork was not done properly. It was either clerical error, his attorney made an error, whatever the case may be. There's absolutely no way he would know that. So yes, he's worried sick. You have a baby in an OF house, okay? And the comments that were coming through were absolutely crazy. Let me keep reading. The 911 audio of John will illustrate his poor demeanor with the operator. Him being clearly bothered by the fact that the operator did not understand how the child's mother had violated an order John could not even clearly describe. He's not an attorney. Again, I don't understand. The case law in California is clear. If the minute order directs a FOAH to be prepared, as the one from 3/17/25 did, the minute order does not serve as a court order. The FOAH does. Not only did Ms. Budnick never properly serve the minute order on Brianna, but she did not file the proposed FOAH until the very same day John filed the ex parte kidnapping RFO, which was 3/24/25. Again, how on earth would John know? This is true. 2K didn't know that this attorney. Right. So again, he was right in his feelings. How there's no way he would have known that. The proposed FOAH and the ex parte RFO were e-filed in the same e-filing envelope, meaning they were filed at the exact same time. 3/24 ex parte RFO are a kidnapping based on a non-existent, since it was never filed, order. Brianna was ordered to not remove W from Dallas County, Texas, and for all visitations to be professionally supervised at times and dates coordinated by the parties. After Brianna hired her current attorney and visitation meet and confer efforts commenced immediately. John decided to add to this order by requiring that Brianna only see W in a visitation facility despite not being on the court's order. But again, remember, I said it's the same line. It's the exact same line. It says, I don't have it in front of me, but it says something like professional monitor slash monitoring center or something. Or the other one is non-professional monitor. It's only 2 boxes. So the professional monitor and the monitoring center on the exact same line. Thank you, Chris. I love those lemons. So again, I don't know how he would have known that. The court later clarified that this was not the order at the 5/2/25 hearing. Unfortunately, that hearing date came after W's first birthday on 4/26, so Bree spent W's first time with him in a visitation facility. Number 4, 3/27/25, DVR number 2, all denied again except for the order not to abuse. This request for a DVRO and the 5/7/24 reverse move away order, RFO, are the things on calendar for the upcoming evidentiary hearing. W is now 16 months old. For the first 3 months of W's life, Brianna had sole custody of him in LA. For the next 3 months before the DVRO trial, Brianna had primary custody of W in LA and John had informal visitation in LA. Post DVR trial, per the step-in order, for almost 5 months, John had primary custody of W in Texas and Brianna had visitation with W in LA. At this junction, W had spent 6 months in LA and with Brianna and 5 months with John in Texas by his first birthday. The kidnapping-based order on 3/24/25 then changed everything, giving John primary custody of W since that date in Texas, and Brianna supervised visitation in Texas. Is 4.75 months of a 16-month-old life a representation of a child's status quo? No, mathematically it is clearly not. Also, recall John admitting that Brianna exercised some of her time with W during the 2/24 holiday season in Texas when the order was for W to be in LA, but John did not broadcast a kidnapping spectacle online to turn a profit over that time in Texas. No. The evidence will show that once John realized this kidnapping idea gained quick traction online and thus quick money, he ran with it. That is the biggest stretch ever. Like, it doesn't even make any sense. Counsel will likely argue that she emailed Brianna after the 3/17/25 hearing to advise Brianna of the new orders, so her lack of drafting, filing, and serving of the proposed FOAH or even proper service of the 3/17/25 minute orders was all water under the bridge. It was definitely not water under the bridge, and I don't think that it's water under the bridge. Again, I think Brianna knew she wasn't supposed to do it, right? And in reality, if John didn't know she wasn't served properly, how on earth did Brianna know she wasn't served properly? So in Brianna's mind, she was served properly because she got the email. She read the court order, so she knew what was going on. Again, it just happens to be a clerical error or an error in regards to his attorney. But nonetheless, she knew what she was supposed to do. She chose not to do it. Service laws, especially as applied to self-represented parties, are there for a reason, and that reason is for the laws to be followed. John filed an extremely inflammatory kidnapping emergency motion after broadcasting the build-up to this filing online for days. Counsel authored this motion and assumedly chose the verbiage used, yet knew there was no signed order in place on which to base the RFO, as she had neglected to file one. Meanwhile, one of the public eye, John sent Brianna one OFW message to ask about W and called the police for a single welfare check. John's public spectacle and his private conduct do not match, which is telling. What? Is he supposed to call the police every single day and send them out there? It was 2 days. It was 48 hours. The motion was filed on a non-existent order, as John's attorney did not file the proposed FOH aids until the exact time as that. She just repeats herself as always. Ex parte RFO. Brianna never kidnapped W. Brianna has never faced any criminal charges for kidnapping, nor anything pertaining to W at all. While John told his followers on TikTok that Brianna kidnapped and was a federal crime, she was never charged with anything. Even after the 5/2/25 hearing, when the court clarified there was no kidnapping here, did John ever go online to correct the record? Of course not, as admitting to such a thing would cause him to lose followers while continuing to talk about the topics that make him money. That is wrong, ma'am. That is absolutely wrong. One, he wouldn't lose followers, and two, he did talk about it. He absolutely did talk about it. He came on and he said that he said exactly what I just said. The shit wasn't filed right, and so technically there's a technical error, blah, 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 blah. I swear, read it. It's because that's all she has. That is literally all she has to go off of, is this kidnapping thing. They keep calling it fake kidnapping. That's all they have to go off. That's why she just keeps repeating it over and over and over again. Okay, requested relief. Around a month ago, when counsel spoke by phone regarding the joint statement for the upcoming evidentiary hearing, Brianna's counsel was encouraged by John's counsel to share Brianna's offer for settlement. John was allegedly interested in settlement. When the settlement offer was shared, the response was an outright no, followed by a counter offer that changed nothing about the current orders. This was not an offer at all. Unfortunately, as anticipated, John seems to have never been interested in settling, as that would eliminate this case from being a topic on his content online. He wants his day in court instead, so that there is something interesting to talk about. Again, ma'am, 2K battles. He doesn't talk about this all day. He may come on periodically and answer a question that is asked. Bree talks about this every single day. Every day. What is Bree going to talk about when it's over? Let's not forget, 2K was ready to finish up with court back in May when they were supposed to have trial. It was Bree that intentionally did not hire an attorney until mid-April, knowing she was going to be eligible for an extension. She said in December, in January, in February, in March, and in April, 5 months, she said, I'm not hiring an attorney until April, because then they have to give me an extension because I just got new counsel. If she really wanted this to be over and she wanted to have 50-50 custody of her child, she wouldn't have intentionally not hired an attorney and had it extended out. That doesn't even make any dang sense. As promised by John online, when he broadcasted his plan to the internet, he took W away from Bree and gave W to his mother to raise. Does that mean I'm raising my grandchild because I watched her while her parents are at work? No. She's with her parents when they're at work. Until last month, John lived separately from W and his mother in an apartment. He routinely went live online from his apartment where W was nowhere to be seen or heard. Ma'am, when you go to work, are your kids with you? Because you have children. Are your kids with you, ma'am, when you go to work? So if I come to your work in the courtroom, am I going to see and hear your children? Because you don't see or hear my kids when I was working, when my kids were little. When you go to my daughter's work, you don't see or hear her kids. When you go to my son's work, you don't see or hear his kids. All of us don't take our kids to work with us. We all have different types of work. He just happens to work online. So I would hope you wouldn't see or hear his kid. You complain if he's online, then you complain when he's not online and you don't see and hear him. You have to pick something. I guess I grasp that you're grasping at straws. But that's ridiculous. Conversely, when Brianna had sole custody of W in LA, she solely cared for W and took him with her everywhere she went. Exactly. Including to the state fair where she was completely inebriated, including to a bar, a sports bar, where the for the World Series. I mean, I can go on and on a boat, on dates, filming, where else, right? So again, God forbid that John be responsible and have his mother take care of his child while he works. Yeah, the boat ride that was a great place for the baby. Right, in bed with... Listen, let me not get another... Keep tapping and hearting and whatever. Ay, ay, ay. Okay. Where was that? Okay. John's entire case against Brianna hinges on allegations of online bullying. Hey, that's not an allegation. That is easy to prove. The same type of bullying as the evidence will show, John has been a very active participant in since Brianna got pregnant. John has even presented a sliver of John has never presented a sliver of credible evidence of Brianna's unfit as a parent. Well, honey, I can do that for you. I'll help you. He has loosely accused her of partying with friends, yet there are hundreds of videos of him online doing the exact same thing as many young adults do in their 20s. Going out with friends while one does not have custody is not a crime, nor does it make you an unfit parent. What about doing snow when you have your child? When the child's only a few weeks old, but you do it at nighttime. Her words, not mine. What about doing... I grasp that Coachella is a whole different time. Like, anything's available at Coachella. I know hundreds of times that John's been out partying. I want to see that. Unless there's hundreds of videos of the same few times. He has no evidence of Brianna even partying around W or exposing W to any part of that lifestyle. Even if he doesn't, your client does, ma'am. Your client does. There's a video of some Diet Coke, you know what I'm saying, out at the house that W was in. No wonder she never let him off the bed. Or exposing W to that type of lifestyle. As John said right before W was born, he did not choose to have a baby, Brianna did, and the primary motivators for all of John's conduct since W was born has been spite towards his ex-girlfriend and monetizing the situation online. Ma'am, do you know how much money he has spent fighting for his child? Over $200,000. I'm not thinking that's a money grab. If you're spending $200,000 to fight for your child, how is it a money grab? Why has your client not spent any amount of money to even care for him? Your client hasn't even sent him a package of diapers. She didn't even know what type of milk he drank. She doesn't even know he has food. Or that he needs food. She doesn't know what kind of food he has. She doesn't know what size he wears. That's not John's fault. That's her fault for not being an active parent. And a court doesn't just give you supervised visitation just because they feel like it. Sure, no problem, John. You seem like a nice guy. I'll just put her on supervised visitation. What the hell? No, it doesn't happen that way. And not only that, that's not even what John wants. John has said many times he wants nothing better than for her to get the help that she needs and be a 50-50 partner in raising their child. Brianna has exercised her supervised visits with W in Dallas County since 4/25 and paid for 100% of those costs. Let's clap it up. A year after the baby's born, she finally has spent some money on the child, minus the $120 of clothes that she bought a while ago. Good job. Proud of you. Those costs included, but have not been limited to, hourly charges for the monitor, which you're required to do because of your actions, Brie. Activity charges for the monitor, same reason. Mileage and parking charges for the monitor, same reason. Round trip airfare from California to Texas. Lodging expenses and expenses for W's necessities needed during the visit and food costs. Do you hear that? Only during the visit. God forbid she paid for anything else. But you know how that you could cut that cost down, Brie? Just leave your boyfriend at home. Don't pay for him to come. All of the stuff that you're doing, all of the activities that you're doing, all the other shit that you're doing outside of your visits costs more money. Yeah, crackers and milk have gone way up in expense, okay? This is crazy to me. It is hard to imagine many parents in their mid-20s making this type of arrangements work, having to travel halfway across the country. Since when is California and Texas halfway across the country? I am literally curious about that. Anyways, halfway across the country for 1 week a month while trying to juggle work and life and essentially paying to live in 2 different states with this in the same month. She doesn't, ma'am. She doesn't do that. She has said absolutely there's nothing in Texas for her. She absolutely will not get housing in Texas. She will not rent a house in Texas or buy a house in Texas. She has also said many times that she feels that she should have, oh yeah, let's not forget the Yogi Whites, that she should have custody of the child because her work is done online, where she can work absolutely from anywhere, at any hours, any time of day. It doesn't matter what time of day or where she's at, she can work because all of her work is done online. Your client isn't a regular client that just works 9 to 5, ma'am. And she brags all the time, constantly, about how much money she has. She's traveling all over the place, going to Hawaii every month, spending weeks on end in different places. She rented a place in LA for who knows what reason, because she's only been there like a week out of the month, because she spends a week in, well, a few days in Texas, and then she's in Hawaii or Miami or wherever else. Anyways, let me continue. John refused to allow Brie to attend W's appointments with him when she was in Texas for her first week of visits in 4/25. Once the court made an explicit order at the 5-2 hearing that Brie could attend those visits, she attended one remotely with John thereafter. Again, that's good, John. Good job, Brie. You've attended one doctor's appointment. You're doing great. John did not discuss milestone moments with Brie on OFW before announcing them online, such as W taking his first steps and W starting swim lessons. John's lack of communication, coupled with his condescending and hateful tone that comes out frequently on OFW, which will be illustrated with the log-in evidence at the time of trial, have all illustrated that he seemingly has no interest in co-parenting with Brie. John enjoys being able to control everything about W and Brianna's interactions. For the last 4 months, he has repeatedly denied Brianna's request to take pictures and videos of W during her visits with him for her own personal use. Unfortunately, she's never used them for her own personal use. He has allowed them, and he also sends them to her. This included the Mother's Day week in May, during which time her mom got to attend these visits, putting her, Brianna, and Winter together for the first time since W's birth. Grandma's in the chat. Can you imagine the first time over a year? So 13 months. Child is 13 months old, and you were seeing him for the first time? That's crazy work. Meanwhile, in repeated violations of his numerous requests that neither party be allowed to post W online, John has continued to do that exact thing, so as to show Brianna who is in control. Despite everything Brianna has gone through as a result of John's litigation tactics, she is willing to put their differences aside and co-parent with John. The parties should share joint legal custody of W and some sort of shared visitation between Texas and California. Winter is not school-aged or enrolled in any sort of child care, so this is a possible arrangement at this age. Again, at 16 months old, before the 324 orders, which were put into place, W's status quo was Brianna in LA for 6 months. Then for 5 months, John was the primary parent in Texas, with Brianna seeing W for 1 week out of the month in LA. Since 324-25, to Brianna's knowledge, W has not been enrolled in daycare, Montessori school, or any local activities in Texas except for swimming lessons. John said online W has recently started. W has now stayed in 3 different residences with John in Texas, if the court is to believe W stayed with John in his apartment. In short, W is not established in nor overly connected to Texas, especially at only 16 months old, when 6 months of his life was spent in LA almost exclusively, which means then 10 months of his life would have been in Texas, right? If he's 16 months old and 6 months of his life was in LA. I'm no mathematician, but just saying. As the monitor reports will show, there have been 0 issues during Brianna's supervised visitations with W in Texas. If there had been, knowing John's aggressive litigation tactics, he would have filed an ex parte at RFO for every alleged issue. So who's the bully here and making just crazy accusations? Tell me that wasn't a snarky ass comment. During the council call 1 month ago, Brianna's counsel suggested that John allow the August visits to occur in a non-professional monitor, with a non-professional monitor present. John's attorney asked to share names of monitors for John's consideration. That was done, and no response was received. John seems to want Bree to stay on supervised visits indefinitely, assumingly, so she eventually gives up on CNW due to the extremely high cost of professionally supervised visits in another state. Right. We all know that's not true. If she put her child first, she wouldn't be in this situation, and she wouldn't be worried about the cost. You know what I'm saying? Because that's the craziest part right there, is talking about the cost when you're spending all this money and everything else. Yeah, this is Bree's trial brief. There is no need for a supervisor at all, let alone a professional one. Brianna recently found out she was pregnant. So unless John is going to argue that he believes Brianna will be out partying while pregnant, it's hard to imagine what concern he has to Brianna's custodial time with W. If he argues that Brianna goes out when W is not around her care, the same finger can be pointed at him. Brianna is very open to the logistics of shared custody across state lines and wanted to discuss this topic with John during settlement negotiations, but John refused to consider anything beyond the current orders in place. Brianna's legal argument, RE, the First Amendment, and how her constitutional protections fit into the DVPA analysis were laid out in her 7/21/25 trial brief. So will not be reiterated here. God, that's the first time she hasn't re-put something in. John 7/18/25 trial brief missed the mark of the court's research question, which was, with the First Amendment in mind, what restrictions, if any, can the court put on Brianna pursuant to the DVPA in the context of John's request for the DVRO? Interestingly, not one of the cases cited by counsel in that brief was a DVRO case. Mind you, her attorney cited the exact same cases. They both talked about the exact same cases. For example, People versus Nixon, a criminal case. Counsel argued the court can impose restrictions on a party's social media usage in certain circumstances. What was left out was the pertinent part of the appellate court ruling, which was that the court could impose that restriction on the defendant since he used social media to commit the crime he was later convicted of, which followed a conviction for a separate crime. Brianna has not been charged nor convicted of any crimes, and this case involves an analysis under the DVPA, not the penal code. Similarly, counsel argues that another criminal case, People versus Blanchard, held that non-tagged posts and live streams do not explicitly mention John can still be deemed abusive since they were made publicly. She tried to compare the defendant's post from that case with Brianna's content in this case. The defendant's actions argument on appeal was that the non-tagged post did not meet the required elements under the Stalking Penal Code, RE, a course of conduct needing to be directed at the victim. This is a DVRO in a civil court, not a stalking case in a criminal court being analyzed as the elements of a criminal court stalking case. Almost done, thank God. Conversely, to this case law, Brianna's prior trial brief cited two DVRO cases, including a recent case trial by Judge Pellman when she used to sit in Pasadena courthouse. In sum, the case law supported Brianna's position, collectively found that the court cannot restrict what parents say about one another online in the context of a DVRO unless a parent's online conduct affects the child's health, safety, and welfare negatively. Then why would you bring up any of the, if that fits for Bree, then it fits for John. As the court previewed at the 5/2/25 hearing, it is most interested in reviewing evidence where W is involved, i.e. he is physically present and being put in harm's way. To date, John's evidence of alleged online bullying completely missed this mark. So because your client is never around baby W, except for when supervised, when she's not allowed to have her phone, then she has a free-for-all. She just gets to say and talk and do whatever she wants, but because he has custody of W, he can't even respond to her questions. Interesting. Obviously, the majority of evidence Brianna has to share against John shows John bullying Brianna while W is under his care, with W sometimes heard crying or making noise in the background while John is disparaging his mom online. I thought you didn't hear John, or baby W, when he was online. He was nowhere to be found. Brianna seeks attorney fees pursuant to FC 6344B, as well as FC 271 sanctions for the filing of the second and equally frivolous DVRO filed in the past year of this case. Oy, sorry. So burning this sitting down and well, gosh dang it. Yeah, apparently that is absolutely acceptable, not harmful at all. Ooh, 888. I don't know. It was okay, but man, now that I'm sitting here all this time, it's starting to, yeah. Yeah, she did try to get people to go to his house. How can she be sure it was bad? Right. They just, listen, they just make up any and all crazy accusations. I will never understand or get why it's acceptable. Yeah, I just don't get it at all. I tagged you in a video, Bree saying, yeah, I saw that. If cyberbullying's not real, then you can't accuse him of cyberbullying. And then what made me sick is when she said, can I go to court with 2K? Well, no, why would I go to court with 2K, love? 2K's got this. He don't need me. He does not need me. He's got an amazing attorney. He is good to go. Nothing I could do. What was I just gonna say? Check my messages. I offered you a free. Oh, you're so sweet, Nunu. No, I have one coming up. I'm gonna go be seen, love. You save that for you. Today, Santos told a person in the grocery store they rescued oh my god, this guy. So did the attorney attach any proof of anything? No, they don't have to. All that will come up in court. So what I'm gonna, trial starts August 22nd. So what I'm going to do, it was okay, but I think I'm gonna finish up here pretty quick and head back because it's starting to hurt. So what I'm going to do is, over the next several days, I have all of 2K's docs up and all of Bree's docs are currently up with no other commentary. They're up on my TikTok. I'm going to grab all of the docs from the very beginning and I'm going to read through them and start posting them every day. I'll be, posting a couple videos a day, and that way we'll all be up to date. So all of those should be up and done by the time trial starts. So everybody will be up to date on all of the docs. I'll just redo them all, post them on here so that you guys will have them. So that way you guys will be up to date. So when the trial starts, we'll go through all that. Then as a reminder, if anybody is new here, I have said from day one, once this is over, once trial is done, I will no longer be discussing this case at all. I have no interest in following Bree and Santos and their baby and whatever it is that they do. I'm just going to continue to follow this. I mean, check your messages, sending you something. Okay, messages on TikTok, right, Queen? Oh, thank you, pretty. I didn't even have a chance to read your message, but I'll go in and read that as soon as I get off. Oh yeah, everyone else, other people I'll continue to talk about, and if they go to trial and whatnot. I saw Anti did the baby's room, so cute. But yeah, everyone else I'll continue to still talk about. You guys can still continue to run the page. Whatever you guys want to talk about, Oh yes, yeah, absolutely. I'm going to go over the final docs. Oh, thank you. It is Glossmetics. All it is a lip liner, and then this is actually the clear one. I love it. So I will do all of the final court docs, and then I'm done. I'm well staffed. Angie, did you see Bree said to... Hey, Debbie. Yeah, she says a lot of things. She will say anything that she thinks people believe. How soon to the final court? Usually a couple days. Yeah. Can you share... Oh, hold on. I saw that one. Can you share what you think the outcome of the trial will be? I think it's hard to say, but I really do think that at this time, for now, Emily, it's up on my page. because I read it yesterday. I was going to, but my back is really hurting. So I don't want to push it too bad. So, but I can reread it tomorrow. But it is up on my page, the whole thing, if you want to watch those videos. Sorry, I was going to read it, but I wasn't planning on having to stop and wait for everyone to come back in. That took an extra 20 minutes where I could have read this dang thing. But my back is really killing me. So I don't want to push it, love. But it is up. I will read it tomorrow. I did want to read them like back to back, but my back said no. Yeah, I can do a poll. So what I think is going to happen is I actually think it'll probably stay status quo for now. Oh no. And yeah, that's what I think. I think he'll stay in Texas. I think he'll continue to have the 3 weeks, and then she'll continue with supervised visits. I don't think she'll have to stay on supervised visits for long if they continue to go well, but it'll be interesting to see. We don't have all of that info. Okay, we'll do a poll. Okay, so poll is red, you think it'll stay as it is. Blue, you think she'll get 50-50. Because I think those are going to be the only two things. So red, it'll stay as what John had requested. Blue would be 50-50. I think eventually if she changes, I think you can get to 50-50. Wow. Hold on, I saw it. Hold on. Can a mod pin my comment? I want Angie to answer the question. Oh, hold on. Let's see what it was. Can someone confirm if these court hearings is only for DVR? No, it is for custody. Yeah, custody will be decided in this trial. The trial is for custody and move away. So what? 10 second, 9, 8. Red is stay as it is. Blue is 50-50. 4, 3, 2, 1. Well, 196-3. It'll stay as it is. Interesting. I don't think she needs 50-50, especially with Santos involved. Well, I think that's going to be I think that's definitely going to be a huge factor with Santos involved. And let's not forget, you guys, since she's been pregnant and she's doing her visitation right now, the 2 hours that she's only spending 2 hours. I think, now my answer may be different if during the last 4 months she was doing the 6 hours minimum a day that the judge asked her to do. Right? But she didn't. She's done 2 hours a day, and now that she's pregnant, those 2 hours, she says she can barely function. She has to take a 10-hour nap after seeing her child for 2 hours. How is she going to have 50-50 custody if she can barely handle 2 hours? You know, how is she going to do it? I wouldn't say she switched sides just because she thinks she's going to get 50-50. I think that's the one thing that Law Talk and I have always had in common, or that was good with us, is we saw things very differently in this case. And I love that. I love getting to have a great conversation with somebody that sees things differently. And again, she's a family law attorney in California, right? So who would know better than her? I live in a whole different state. I do a different type of, absolutely, as long as it's respectful. I do a different type of job. I'm a social worker that works in a legal setting in criminal court. You know what I'm saying? So my things are very, very different. Yeah, 50-50 legal custody is common. And it could be that he gets physical custody, and then there's like a 50-50 thing to where she still has like some legal rights. I was going to show... where do you want me to send? To my email, love. You have my email, right, homie? Lawyer said he doesn't think she'll get 50-50, and he's in California as well. Yeah, I don't think she'll get 50-50 just yet, but I mean, everyone's open to their own opinion, so I don't think that means she switched side. Thanks, Steph. You're the best. Let me pin it. Oh, here we go. There you go. Harmony. Right, I think the pregnancy thing, she truly feels that, oh, baby, WV Mama, every day you send me my beautiful flowers and butterflies before I get off. I swear it helps me sleep. Butterflies always remind me of my mama. But I forgot what I was just gonna say. You're welcome. Oh my god, you guys, 140,000 likes. You guys are amazing. Apparently she said that she believes that she'll get 50-50 custody. These mother chuckers really fucking irritate me. Coming in here with all that nonsense. Why did she rush to get pregnant? She believes that if she's pregnant, thank you guys so much for the gifts. If she believes that she's pregnant, that makes Santos' family, legal, not physical. That makes him family. And what is this? Oh, 50. Oh, I had a goal. Oh, thank you so much. That makes him family, and that he can be around the baby, but it's not true. I forgot to do that. When did Ayla check so that I haven't? Someone sent me a screenshot. She wasn't in she was in our chat, but I didn't see it. I'm just guessing what. Well, of course I'm guessing. I'm not the judge. I can't determine the case. What do you mean? I don't think she'll get 50-50, legal or physical. At this point, I don't think she will either. Thank you, WV Mama. 80% of the live goal is reached. Baby, it was doing a lot better. Oh, maybe it's the patch wore off. I wonder how long these little patch things last. Because, yeah, I've been sitting for too long. Let me see. When did Ayla say to her? I haven't seen her. I guess she was in here a while ago, and then she was on somebody else's live and said it. So, I don't know. I didn't see it. I mean, someone sent me the screenshot. But, yeah, I don't know. Yeah, I don't know what she would do with them. She, like I said, she 2 hours and she's done. She needs a 10-hour nap. Oh, she was not in here? Oh, I thought someone said she was. No, thank you. Oh, you guys reached a goal. Thank you guys so much. Thank you, loves. I still appreciate you guys. Yeah, I thought someone said she was. I didn't see her in here. Because I said, if you guys see her in here, just pin her. Oh, it was a different live. Oh, okay. It's damn puzzle. At least this one's pretty. There we go. If she finds out she's having a boy. MCRI said the exact same thing. Somebody asked me. Court stuff confuses me. And that's why I try to come on and try to answer as much as I can. Again, I'm not a lawyer. But doing the work that I do, you kind of learn like what the forms mean and how to read them and whatnot. So I try to answer as much as I can. So feel free to always ask questions. That's why I'm here. But back to the thing. The only thing I can think of as to why she wants to find out so early is for that reason. You only have up to a certain time to do that. Did you cover H? What does that mean? Oh my god, my back. Can I get anyone's opinion? Anyone's opinion on what, love? And it makes me sad though, because Santos already has a girl and he's like, I really want a boy. Heather, I forgot about that. Heather has a law background. Okay, what's your opinion, Heather? She'll claim it. See, my people, I know. I sent you the ultrasound from today. Oh, I think I got that. Let me look at that. Let me see. Cause.
Okay, so I watched Angie W.
Oh, I love Angel. Look at her. Let's see here. So, this is a real ultrasound.
What does that mean, babe? That policy?
That's the steak I ate this morning.
Oh my goodness. Hey, I made you some good steak and eggs.
The one that they did, let me see. I should do it.
Yours right here. That's your bladder up here. This is the gestational sac. And at the
It looks like there's two there. Like, what-
Yeah, it's just a yolk sac still. Yeah. Apparently the ultrasound says she's 6 weeks, not 8 weeks. She's been saying. I was gonna say it's still a yolk sac, so that's a very small baby. Maybe she now is actually pregnant. Yeah. She got a whole tattoo to make her lie convincing. Wait, what? Wait, really, Kim? No, I thought that was only like the day after. Wait, is that the morning after? Honey, I'm old. It's been a long time. I don't know. Is being in the morning after? Are those the same thing or those are different things? Oh, different. Okay, I was like, wait a minute. Okay. Oh, God. Same thing, different thing. 6 weeks, 1 day math I got. April 7th due date. Interesting. So she told us a little before she actually was. Morning after. So that's what I thought. I was like, wait a minute. Plan B, that would be different. Okay. Judges do the step schedules to see if you will... Exactly. That's how it's done here too, right? So you do step schedules. So first of all, hers would have been the professional monitoring with no issues, not missing a day, doing all the time, etc. Now let's not forget the judge said, I want to see you do at least 6 hours a day. You can do up to 10. She said up to 11, but 10 because that's all the monitoring place will do is 10. I want to see you do up to 6 to help. Let me see how you do and help I can't remember the exact word, but basically bond or connect with W more. She went from 4 to 2. So she's not doing that. The next step after doing that for so long, typically here it's usually 6 months. And then after that, then it would go to a non-professional supervised visitation for 6 months with no mess ups. Here you mess up, you go back to day 1. Or back to step 1. And then after 6 months, then you go to that. So it'll be interesting. Yeah, she's not bonded at all. Right. I just can't get past the no food. I cannot fathom. Like, as soon as the baby's up, we change. We, have our little bit of playtime, but within 30 minutes of her getting up for a nap, she's eating a meal. Yeah, I'll have to look and see. Yeah, not in 4 hours. I can't fathom. If she has a long nap or whatever, she's up and she's ready to eat, like right now. Typically, I'll have to give her a snack while I'm making or something. I just can't fathom. Literally. And more than crackers. Even if they got married, they could say something. Absolutely. Yeah. Just because of his background. And again, you guys have to remember, they just had a DV situation in July. Just last month, he was arrested for DV against Bree. Literally, Kaylin, my 1-year-old granddaughter, she can eat. I tell you. Yeah. Yeah, if it's a safety issue, absolutely they can. Absolutely. That'd be equivalent to you marrying a P3DO and saying, well, that's my husband, so he can be, Granted, that's not his charge, but he has some stuff on him. So, but again, I am not the judge, so I don't know. Okay, let me do these last few ones. I'm going to go. Will the judge physically see the video? Yes. Yes, all the ones that were put on 2K's list. And if you aren't sure what those are, they are all the videos are on my TikTok of me just reading them. There's no commentary, and they're all tagged. So read the one that says 2K's evidentiary list. Or sorry, 2K's evidence list. And then I also have Bree's evidence list up. And you're going to see a lot of Bree's is going to be not used because it says, the judge says evidence is to be used only from the date of his birth until current date. Even if it was dropped, can it still be sued in court? Santos DVR debris. Oh yeah, it'll still. You mean used? I'm assuming you mean used in court. Absolutely. It was already brought up. It's on his evidence list. Yeah, it will definitely be used for sure. Crazy. All right, guys. Well, I love you guys so much. We had 2 great lives in a day. We'll go live again tomorrow. I go live almost every day, and all videos are. Thank you, love. We'll go live again tomorrow, and what I'll try to do is, I'll try to plan and put some of the things together, to like that are contradicting between 2Ks and Breeze through their thing, and we'll kind of do it like that. But I love you guys all so much. I hope you guys have a great and amazing night. You guys are amazing. And I'll see you guys tomorrow. Have a good night. Bye.